Good afternoon and welcome everybody to our monthly meeting for lawyers doing post-conviction investigations and litigations. My name is Marissa Bluestein. I'm an assistant director at the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School. We are a training and technical assistance provider under the Bureau of Justice Assistance Grant for upholding the rule of law, preventing wrongful convictions, as well as for post-conviction DNA. And we host these meetings to provide training and opportunities for folks in the field just to learn more about topics of interest to you. One of the topics we get a lot of requests for is about investigation. So I invited our guest, Denny Butler, here to be with us today. And I have to tell you, in all honesty, when Denny was suggested to me as just somebody to work with in general, I was a little skeptical, Denny. I don't think I've told you this. I apologize because like probably most of you, I get information about folks doing post-conviction work or investigations or other things trying to help people in prison who are innocent. And I personally have been burned by a lot of those groups, by groups that either do an investigation but do it in so poorly that they wind up making the position worse for the individual who's in custody, or maybe they take their money and never give them any results. So I'm sorry, Denny, but I was a little skeptical when we first met. But after talking with Denny and learning about his background, learning about him, I can tell you Denny's the real deal. He's been working with some conviction integrity units and also some innocence organizations around the country from his home base in Kentucky, doing the hardcore investigations that actually result in justice for people who've been wrongly convicted. So Denny, I'm so thrilled that you're with us today. Denny is a former state representative. He's a former police officer, homicide investigator. You may have seen him on ANI, First 48 Hours, but he's also the director and founder of Clemency Investigations, which is a nonprofit organization that looks to work with people who have been wrongly convicted to try to do the hard investigation that needs to be done in order to prove their innocence, to be able to achieve justice for them finally. So Denny, thank you so much for being here. Denny's going to take it over and kind of talk a bit about some of the cases that he's worked on, but this really is more aimed at being a bring your questions case. So there's too many of us, I think, to allow to have people unmute and ask questions. So please put any questions that you have in the chat. I will be monitoring that, and I will be able to kind of let Denny know what we got when we're going. So Denny, welcome. Thank you so much for being here. The floor is yours.
Yeah, no, thank you, Marissa. And it's an honor to be here, and appreciate all the hard work that everybody does on these cases. I think it's important for everyone to understand kind of my introduction and pathway into the wrongful conviction world. And I'll go through that some and then talk about the process for a review, and it's more focused on the CIU units. And then the actual review itself, kind of and I'll use a template of the case I'm going to talk about that introduced me into the wrongful conviction world. And then from there, we'll talk about, the report of our findings and kind of after the review, what could happen, should happen, things like that. Each case is unique, and I'll try to pull examples from the case originally that introduced me into the wrongful conviction world. So I started my police career in 1991 with the Jefferson County Police Department in Louisville, Kentucky. And then in 2003, we went through a merger. Louisville, Kentucky, Jefferson County merged governments. The Louisville Police Department had about 800 policemen. The Jefferson County Police Department had about 500 or 600, and we merged to one happy family. And it's been eventful from there. You've probably heard of the new department. LMPD has been in the news recently with the arrest of Scotty Scheffler that was soon dismissed. And then in 2020, the death of Breonna Taylor was at the hands of the Louisville Metro Police Department. Since the first case I was involved with in 2009, Edwin Chandler, it came to me through the Kentucky Innocence Project. And I was a sergeant in the homicide department and didn't even realize that there was a Innocence Project in Kentucky. And when Marissa says she was skeptical, it would be an understatement to say that I was skeptical. I spent a career in investigations and put a lot of people in prison. Edwin Chandler, to make a very long story short on him, was exonerated, and I actually was able to charge the person who did the murder. Since then, the same department that I worked for has had 6 homicide exonerations. And, it's just, to me, it's shocking. You only know what you know. And I was part of this system that was responsible for 6 innocent people going to prison for murder convictions. And it just, so that's kind of where I'm coming from. Edwin's case came to me from the Innocence Project in Kentucky. And I'll try to make it very brief. It was a gas station robbery where the female clerk was shot in the head once by the assailant. It happened in 1993. The case was actually on VHS videotape, which in the time in 1993, it was one of the first cases in Kentucky that I'm aware of that where you had a video of an actual murder. Um, they had 4 different cameras in the little store, and they had actually caught the perpetrator before the shooting, during the shooting, and then after the shooting, and that was collected as evidence. And that night, it was the part of the murder that was videotaped was erased by the lead detective by accident. Um, when the Innocence Project called me, I knew nothing about the case. And they gave me information that said, they said they had an eyewitness that was there who uh, claims he knows who the shooter was, and it wasn't Mr. Chandler. Like I said, there was a video. Mr. Chandler had actually confessed to the murder, and the Supreme Court of Kentucky had actually upheld his conviction. And so, I'm getting into this thinking, I'm going to call this Innocence Project investigator back in a day or two and, set him straight and show him he doesn't know what he's talking about. And uh, to my surprise, I got the case that night out of archives, started going through it, and some things stuck out that just didn't seem right. And I call it the homicide basic 101. It just didn't match up to me, and started digging in deeper. To make a very long story short, the information from the actual killer and the information from the original witness that the Innocence Project had, their names were nowhere in the file. And about a year into the investigation, we were able to clear Mr. Chandler and charge the fellow who did the murder. And then that started an odyssey of about 10 years. I retired in 2012 from the police department, and had no clue how the system works on exonerees. Edwin and I stayed in contact. It was very limited at that point. And then I got a subpoena to appear in federal court for a deposition in a civil case. And it opened my eyes to a world that I was part of and didn't even realize. And it started with the county attorney that represented the county would represent us as well for other lawsuits and things like that. And so there was a policeman that we had charged with some embezzlement, and we were sued on that case. And so she used that to say she represented me personally, and that it was just really weird. And I got a call from, and I've retired at this point. And I got a call from Edwin's civil attorney in New York, who I didn't know. And, I told him, I said, just send me a subpoena and I'll be happy to talk to you. And then I called the police department just to let them know, hey, do you know we're being sued? And not knowing that the depositions were already taking place and things like that. And the county attorney that I was working with asked which side I was on. And yeah, I told her at that point, I said, well, you can just send me a subpoena too. And I hung up on her. And it blew my mind that, that this stuff goes on. We exonerated Edwin. I walked out of the courtroom, and the Innocence Project attorney that I was working with pulled me aside and said, hey, we've got another case for you. And I thought, all right, when's this going to end? And she said, no, really, this is the only other one. And it was another homicide case, unrelated. His name was Kerry Porter. He was exonerated in 2011. And that case went through the federal system and settled as well. Edwin was paid $8.5 million. I think Kerry was paid $7.5 million. And the frustrating part for me being a part of this now is seeing how the police department, the government dig their heels in, not only to defend a wrongful conviction, but then they do very little to nothing to change the system to help prevent um, future cases, or just to improve the system. And that was really the eye opener for me. So Edwin Chandler's exoneration led to three more exonerations by the same policeman. His name was Mark Handy, and having retired in 2012 and going through depositions off and on in federal court and hearing the name, I had a federal murder case in which the U.S. Attorney, Jim Lasowski, who's since retired and is now working with me, we were working that case. And in our travels, I told him about, Edwin's case and Mark Handy. And we started to dig in on Mark Handy. And 10 years later, we were able to hold him accountable. And it took us uh, getting a special grand jury appointed. It took us getting a special prosecutor appointed. And at the end of the day, he pled guilty to two of the cases, one for tampering and one for perjury, and spent 11 days in jail. And that battle to hold Handy accountable really kind of opened my eyes that this world is, there's parts of it. If you don't know what you don't know, you don't know it. And as you dig deeper, if something stinks, it probably stinks for a reason. And I have a consulting company where I was doing reports for police practices, police investigations on 1983 claims across the country. And then in 2020, I thought, all of these folks that I work with or have worked with in the past, none of them have the resources to battle the system. And so I opened up Clemency Investigations in 2020, a nonprofit, and wanted to create that same atmosphere that when I was a police sergeant and the Innocence Project called me, I didn't have to go and file FOIAs. I just went and got the files. And being part of the system, nobody questioned what I was doing. And once I got all the information and was able to go through it and kind of, for lack of a better term, put the puzzle together with all the pieces, we were able to exonerate Edwin. So what I wanted to do is try to have a nonprofit do that same thing, create that same atmosphere where I can get the information, take a look at it, review it, give a confidential, independent report back to the CIU we're working with to show what we found and whether it leads to relief, exoneration, or we got the right person. And we have partnered with a few CIUs working through it and hope to partner with a lot more. The review process, there's no right or wrong. And I think what the Cary Law School and what Marissa and them are doing, I mean, here you get to learn of the best practices. The stuff that I'm talking about is really personal preferences. Having worked in police world for 21 years, I mean, I've seen many different ways to interview people and you just have to pick the one that you're comfortable with and go through there. But the critically important thing that I can't stress enough on these reviews is the collection of the information on the front end. You have to get the information from the police department, the original police file. I prefer to see the files in person and make the copies because you can kind of see how it's put together. And I've seen cases on 1983 claims where there's actually folders that have a sticky note that say "Do not copy," and those were never turned over. And it was a six-pack identification of the actual killer, and they kept that away and put the wrong guy in prison. So you have to develop that partnership with the police department to be able to work hand in hand with them. I find it very disgusting for police departments not to cooperate with prosecutors for these reviews. If someone ever questioned one of the cases of mine, I would wholeheartedly participate, answer any questions, and want. I would be proud of the work that I've done. And what I have found is typically the ones with a lot of questions to it, the police department are not proud of the work they've done, and they don't want anybody looking at it. So the first batch, and I call them buckets of information, you have the police department, you have the prosecutor's file, you have the trial transcripts, um, and you have the defense file. Those you have to have to start a review. That's the way we started. I like to read the trial transcript first, see what the arguments are about, and then uh, almost in every case, without question, there's a cheat sheet laying there, and that's the defendant and his defense attorney. And I usually go and talk to the innocent person or the person with the claim of innocence, and having some very limited background, just let them walk me through it and asking the questions of kind of homicide basic 101 and finding and then taking that interview and applying it to the rest of the investigation. And a lot of times it's not what we find, but it's what's missing. And why they didn't interview this person or why they didn't go and get this cell phone information. And that's where your first batch are those buckets of information. And then through those reviews, it may lead to other collections of information from crime scene lab, from medical examiners, from autopsies. And when you're getting this information in, you have to have a system where you're collecting it because there's just so much information to where you're naming the files and you know where they're going from. Because a lot of times once we get them, we communicate through Zoom with the CIUs, and we're talking about maybe uh, one file in a file that may contain 1,000 files, and we all have to know what we're talking about and uh, where we're going with that. Other challenges that you're seeing that I've seen, like in Edwin's case, and I think it's throughout. We had a merger in 2003 with two police departments, and in that files are moved, evidence is moved. The property room in Louisville had moved 3 times since his conviction, and there was a new courthouse built. And one of the issues that we came into and I tried to address as a state representative was the judge's rules with property that goes through trial. Some judges think that's their evidence, and others would tell the police department to come get their information. In Edwin's case in 2009, we found a box of evidence that was stored in a closet only because the clerk at the time, when we were building the new courthouse, thought it could be important, and they literally had a 10 by 20 room stuff from floor to ceiling with evidence out of lockers from all the old courtrooms, and that's where we found Mr. Chandler stuff that actually led to his exoneration. It was a fingerprint on a bottle that was collected that ended up being the perpetrator. So you've got challenges that you're going to have just with it being a police department sensitive cases, but then these other challenges of just the timing, property rooms moving, things of that nature. When we get into the review of the information, like I said, I like to review the trial material first, the motions, the arguments, and then interview the person with the claim of innocence. And part of that too is reviewing their claim of innocence with the unit. Typically, that's a cheat sheet for us, but I would caution you to not get tunnel vision with that, and stay open-minded and looking for everything. What we do after we do that, we develop a strategy of where we think some high interest points, people to interview, things like that. But we also share that with the CIU and work collaboratively with them so they know what we're doing. So if we're going to go and interview a policeman or a prosecutor, they're going to know in advance. And, many times on the prosecutor end of it, they want to do that in-house, and we're very supportive of that. Let's see here.
Well,
The
actually,
system.
Denny, while you're paused
Right.
there, Could you tell us, so on this issue of investigations and witness interviews, how do you decide who's going to, yeah, you're in Kentucky. Do you go to jurisdictions where you're working with a jurisdiction and conduct those investigations and interviews yourself? Are you giving advice on how to conduct those interviews, or they do more collaboratively? What's the process for you guys?
No.
And
So
what do you recommend?
usually, yeah, no, usually once we develop a strategy and come up with a list of folks to interview, uh, and I don't want it's approved with the CIU, they understand what we're doing, then typically what I'll do is I'll reach out to two or three of the witnesses in advance and set up meetings with them and then travel to the city. Um, More times than not, everybody's within that city still.
Hmm.
And then we conduct the interviews in person or try to. You know, some people are uncomfortable, they don't want to, and we understand that. And, we're very straightforward with the interviews. We're not trying to play games with them. And more times than not, it's more of a conversation of, hey, you were involved in this case. There's some questions in this case, and we're just looking for an explanation, and then letting them speak from there.
So there
Whether
are
it's
a couple questions. I'm sorry, I cut you
okay,
off. I apologize. But
no,
in the chat, one is, would you be willing to share that cheat sheet that you mentioned with us?
well, no, the cheat sheet is what comes from the attorney and the person with the claim of innocence. Usually, they know what happened in their case, and it's not like we have to go digging through thousands of files to find.
Right.
Typically, there's a red glowing light that they point us to. Um, the only thing with that is I would caution you not to get tunnel vision on focusing just on that. Our
And
focus when we're getting into the reviews is also any Brady or Giglio, and then sharing that with the CIU and figuring out, do we need to do some work on that end, either for the Brady or the Giglio. And I cannot see the questions. I don't know how.
I've got
So
it.
okay, good.
So obviously when you're working with the CIU, you may be, and the applicant may be represented.
You hit your mute.
I
Yep.
did. Um,
Yeah.
so the person may be represented or they may be unrepresented. So if you're working with the CIU, obviously you're going out ish on behalf of the government to talk to a criminal defendant. Kind of how do you navigate that either with somebody who's not represented or somebody who is represented? Does counsel agree to that? Do you have them come along? Do you not do those interviews if somebody is represented? How does that do those
Yeah,
nuances kind of
so
play
we,
out
we
for you?
coordinate that with the CIU, and the CIU gets clearance through their defense attorneys. If someone has a court case pending or an appeal pending, and they're in custody, we're not going to talk to them unless their defense attorney knows about it. And
Okay.
then anybody that we talk to, we tell them we're not sworn, we're not here to we don't have any authority, but what we're going to do is we're going to write up the conversation we have with you, and we're going to give it to the folks that do have the authority and the ability to make some decisions. And we let them know up front they don't have to talk to us.
Okay.
Yeah.
And if the person says, no, I don't want to talk to you, does the investigation stop there, or is that just you just skip that step and move on?
No, just that conversation would stop. And then we would convey it back to the obviously in writing. I don't do recordings. It's just a preference, unless the CIU wants to. I've not run into that yet. But what we do is if it's a critical um, piece of information, we may get an affidavit put together and have them sign an affidavit, or we've used the grand jury in the past for testimony to cinch it up. But we try to make it very, I guess, as low key and less threatening as we can.
Mhm.
It's a little different than a fresh homicide, so to speak, because these folks have already been involved in the system for the most part, and they know what we're coming to talk to them about. And usually it's, we just lay out what we're looking for and say, we're looking for an explanation for this. And then, let them explain. And, more times than not, we either get the answer or we get to the point where there is no explanation.
And so if the defense lawyer says, no, I don't want you guys talking to him without us, or I don't want you talking to them at all, that doesn't stop the investigation. You still continue on?
Yeah, we'll still continue on. We won't go and interview that person. Obviously, if someone wants their attorney present, we're happy to have their attorney present. And if they
Right,
don't want to talk to us without an attorney, then we won't talk to them without an attorney. And we've had that come up. And we've also stopped interviews where a co-defendant in a case was wanting to talk to us, but at some point he would have been incriminating himself, and he knew that, and
right.
he became. Uh, he told us that the person claiming innocent is innocent, but he also told us, and the way we phrase it to him is, we don't want you lying to us. If you're uncomfortable answering a question, just to say you're uncomfortable answering the question, and we can read between the lines. And at some point, he
Right.
said, I'm uncomfortable with answering the question, and would like to talk to an attorney. We just ended
And
the
I
interview
think
at that.
that actually leads to another question, which is like, what about folks who are you consider alternate suspects, or either going into an interview, or I think you just kind of answered it, if it happens while you're doing an interview, do you take a different approach with folks who are alternate suspects, or what is your approach with that?
So in the case with Edwin Chandler, I was a policeman, so it was a little different to where I had
Okay,
the
yeah,
authority and
right.
knew kind of what lane I was in. I think with working with the CIU, if we're going to go talk to an alternative suspect, or if one readily becomes apparent to us, I mean, we're going to relay that back to the CIU and kind of let them make the call on how they want to handle that.
Right.
Yeah.
Which makes sense. So you mentioned before that you don't record. Why is that? I mean, obviously, if you're interviewing somebody in prison, you can't.
Right.
But if you're interviewing somebody in their living room, why not
It's
record?
it's just a personal preference of mine. Typically, it's two of us, and then what we do is memorialize it in a written report back to the CIU. Um, that evening or the next day. So we do memorialize it in a written report, and then if they have some information that we think is critical to the case, then we'll contact the CIU and see if they want us to go back and get an affidavit or something to secure that statement.
Hmm. Hmm. Um, and there's a question in the chat about it. Was there anything in particular about the Kentucky Innocence Project's initial reach out to you in Mr. Chandler's case while you were on the force that you found that got you to get involved and to work on the case with them?
It was an investigator. I didn't know him. He was a retired Lexington policeman, which Lexington is about an hour and a half from Louisville. Like I said, I didn't know him, but he was straightforward with me, and and I think that caught me. He told me that they had an eyewitness, but he also said, "Look, I'm going to tell you right now that our guy confessed to the case, and it's a false confession." I don't. I think if he would have not told me that, I would have found that. I would have kind of thought, why
Mhm.
didn't he tell me this? I was skeptical like you were when we met. It's just I don't, and it's not taught by the police department to not talk to defense attorneys or not be friends with them, but it's just it's not a normal relationship.
Right.
And I never saw it that way. And when the Innocence Project investigator um, said our guy's claiming he's innocent, I thought we had a duty to look at it, and I thought within a week or two I'd be calling him back saying, "Hey, the guy's guilty, and you need to move on." But it just that wasn't the case.
Right.
And I think he was more surprised when I called him back the next day and said, "Send me everything you have," and then requested to talk to Mr. Chandler.
So, Madison Lowry, you have a question in the chat. It's about a case that you're working on. So, I'm going to ask you to go ahead and unmute and ask the question yourself, if you don't mind.
Hi, yeah, I can do that. Thanks for being
Thanks.
here, Denny. So we're investigating a case right now that has to do with a robbery that was committed with like a somewhat unique weapon in a unique way. And so we're just wondering whether it would be possible to pull records about similar robberies that may have been reported. Is this a type of records request we could do? And if so, how would you suggest going about doing that?
Probably working with the IT people of the police department or the government it falls in. I know one of the CIUs we're working with now, what we did is got with the IT of the government, because the government usually allows the police department to use their own IT stuff to where it's stored, and they will be able to manage how you can search that information. And I hope that answers your question, but the IT folks within the government that you're dealing with, not the police department, but the government, should be a good avenue for you.
That's really helpful. Thank you.
And Des, you have a question in there, also kind of going back to the Mr. Chandler's case. If you don't mind, I think having you guys ask the questions works a lot better. So Des, if you want to unmute and go ahead and ask your question.
I feel like during the preliminary police investigations, claims of innocence happen often, maybe not often, but more than we acknowledge. So what made that case specifically stick out and make you ask more questions versus some of the other ones you may have been exposed to?
Well, so Mr. Chandler's case was the first claim of innocence that it was my introduction into the wrongful conviction world. When I pulled the case from archives that night on my way home, we were redeveloping our cold case unit on how we deal with cold cases, because we merged governments in 2003 and nobody merged the two homicide systems. So we had, I want to say it was about 100 county open homicides that we had no clue where they were. And then we had 400 city homicides. And so we were able to merge all those together. So I was dealing with a lot of the older cases. And when he called and said, you know, we've got this information, and he gave me the name of the eyewitness that was at the scene. He gave me the person that he claims he saw shoot the victim. When I opened up that case file, and I was a supervisor, so you know, I read case files every day and know kind of the sequence of information, how it comes in, where it should be stored within our police department. And when I was reading through that, Mr. Chandler was actually turned himself into the police department. Heard that he was being looked at. He had a warrant for a bad check, and turned himself in, said, "Hey, I didn't do it. I'm here to clear my name." And from there, he was interviewed by two detectives and gave a 35-minute tape recorded on a cassette tape, 35-minute description of the who, what, when, where, why. Out of that 35 minutes, he's probably speaking 31 minutes of it. Police are asking a question, he gives an answer. They then ask him to take a polygraph, and he goes in. We don't have a record of the polygraph, and the history I got from that polygrapher was he would say, "Hey, do you want this person to pass or fail?" It was that kind of polygraph. And while he's taking the polygraph, Mark Handy, the lead detective, shows up and is told that he fails the polygraph, and then he has some one-on-one time with Mr. Chandler. And according to Mr. Chandler, I haven't talked to Mr. Chandler at this point, so I'm just looking at the file itself. And what stuck out to me is in Handy's investigative letter, typically when you have a defendant saying, "I didn't do it," there's something that you hit upon that transitions them from, "Okay, I did it. This is what I did." And in the Chandler case, he said, he describes in his written report that he's talking to Mr. Chandler, and Mr. Chandler bows his head and says, "Okay, you got me. I know that the guy in the White Sox cap, and the black guy with the White Sox cap in front of me, saw me. So you got me." And he writes that in his investigative letter. From that transition, he then goes and gets one of the original detectives that interviewed him, a sergeant, and they do an 11-minute taped confession where Mr. Chandler cannot, he gets the gun wrong. He gets that there was a hat recovered at the scene that the perpetrator was wearing that had a Georgetown logo. He guesses 3 times on this tape recording, and they finally tell him, was it a Georgetown? And he says yes. And to me, when I was reading this and I'm reading the investigative report, and I'm thinking, if I'm doing this, or if I have someone under me doing this, and I have someone transition to I didn't do it till I did it, I'm going to sit down on the tape recorder and go through the rights and all that. And I'm going to say, hey, we just had a conversation. You transitioned, you said what? And let him, there was nowhere where this White Sox cap was put in there. And that kind of slipped through the trial, and that became the key piece of the perjury against Mark Handy, because we knew once we got the video, we knew the last 4 people that were in the store, and it wasn't Mark Handy, or it wasn't Edwin Chandler, but there was a black male who they knew at the time of trial who was wearing a White Sox cap, and Handy knew that the day after, and he was the only person that would have known that. And then he put that very intimate piece of knowledge into his investigative report, where from my standpoint, from an investigator, you would put that directly into the statement. And you would go back to say, hey, we had this conversation. You described the guy in line. Could we go over that again? And none of that was there. And Handy didn't handle the 11-minute false confession. It was one of the original interviewers, and I could tell he was getting frustrated with Mr. Chandler not being able to answer some of the questions thoroughly. And Mark Handy intervenes and says, hey, you were treated nicely, nothing else. We're going to go ahead and end this conversation, and shuts it down. So I have that, and that's what kind of stirred my curiosity. But more so, the second person in the first interview, the second policeman, was a black male. And he, in his investigative letter, writes after the arrest, post-arrest of Edwin Chandler, he writes in his investigative letter, it should be noted, when the writer was with Mr. Chandler, he denied any involvement in this crime. And I know that that detective would have written that after Chandler was arrested. And I kind of felt like this was his way of saying, I don't want any part of this. And then when I talked to Mr. Chandler, I got the full story that, the reason he gave the false confession is Handy was in the room alone with him, and Mr. Chandler's mother had just passed away. He was staying with his 21-year-old sister. He was 19 at the time, I believe, and her 2 children. And Handy threatened to have her locked up for harboring a fugitive and put the kids in foster care if he didn't confess. And then said, if you confess, we'll take it easy on you. You're going to get a 5-year prison sentence on this bad check. We'll just merge it all in. And so he gave this false confession to protect his sister. And obviously none of that was written down or in the police file. And I got that from Mr. Chandler. And that's what I kind of talk about. That's the cheat sheet that we're looking for. And
yeah, but that rang true to you, him saying, these were the threats that were made to me. You credited that, as opposed to
absolutely. Yeah, no, absolutely. And once that became a key piece of evidence in his exoneration, and I think this goes for all the cases, once you find that one piece of information that is questionable, we tore into everything he said in that statement. And he made a statement, the policeman that wasn't involved, that found the hat or was questioning him about the hat, said, where did the hat and the sunglasses that were recovered at the scene, where did they come from? And Edwin, just out of for whatever reason, says, well, I was a neighbor. I stole it from a neighbor of mine, Ed Karpinski. And so when I interviewed Edwin, I'm asking him about everything in that statement. And I said, why did you bring Ed Karpinski into this? And he says, I was throwing football with him earlier that day. And it just popped in my mind. And so I went and found Ed Karpinski and interviewed him. And he's never had anything stolen from him. And, you know, he was very defensive right off the bat saying, you know, I don't want to be involved in this. You all try to get me involved. And I said, whoa, I'm taking a look at it right now. And he said, well, I think Edwin's innocent. And that's what I do too. And it kind of threw him back. But then talking through it with him, you know, the police came and interviewed him, and he was an alibi witness for Edwin. I mean, they were out throwing a football and heard the police cars rolling up to the scene.
Right.
But that none of that was put into an investigative letter, and he said he had shared that with the investigator. So, I mean, that's, you know, so to get back to your original question, that whole description of the White Sox cap of the guy being in there, the only way Edwin would have known that is if he were there. And we knew he wasn't there once we looked at the rest of the evidence. And that ended up being a perjury charge on Mark Handy that he pled guilty to.
Nicole DePalma, you have a question in the chat also. If you're comfortable, you want to unmute and go ahead and ask.
Sure. What do you do when you have prosecutors' offices and police departments that are hesitant to turn over files for whatever reason? Pride, ego, fear of actually uncovering something that may lead to an exoneration. How do you deal with that?
Well, that's a tough one. And I'm happy to talk to you one-on-one about this, but I don't know what state you're from.
New Jersey.
New Jersey. You know, I think the answer to some of this stuff that we're dealing with is each state should have a conviction integrity unit at the state level.
We do.
In my opinion,
we do in New Jersey.
Excuse me?
We do. We have a statewide conviction review unit. My question is, we are a part of the Attorney General's office. We deal with the prosecutor's offices. We don't want to alienate the prosecutor's offices that we work with, but we do have some resistance from counties. How would you deal with that?
All right. So I'll use an example on Mr. Chandler's case. We were being told that all the information on the other cases, so I retired in 2012. The other cases were involved in the criminal prosecution. And I think Jim's going to be in August and he'll talk more in depth about it. But we were able to utilize the grand jury to send out grand jury subpoenas to say, you know, hey, we're trying to do this nicely. We need this information. You know, if you don't want to give it to us now, here, we'll give you a grand jury subpoena and you can just give it to the grand jury and explain to them that you're providing all the information to them. And that became very useful for us because we had members of the police department that weren't giving us information. And we had a prosecutor's office at the time that wasn't extremely cooperative either. And using that grand jury or I don't want to say the threat, but just the use of the grand jury. I mean, we used it for witness information. We'd have a witness that wouldn't call back. And a lot of them are the policemen that are in question and they don't want to call back. And we would, you know, send out a grand jury subpoena to say, hey, show up at the grand jury on this date and you can answer questions there. Or in lieu of this, you could call Jim and Denny.
Okay.
And, you know, if that's, and that more times than not got us where we needed to be.
Thank you.
Nicholas?
Yeah. Sorry, you don't record your interviews. I'm sure you take steps to avoid contamination of the memory of the people that you're interviewing, but how do you prove that you didn't contaminate their memories if you don't record the interviews?
I think it's just a personal integrity thing. I mean, I've gotten a false confession before in a burglary case and realized it. I mean, if the person's saying he or she did the crime or whatever you're interviewing them on, I want the information from them. Any of the intimate knowledge, we wouldn't share with them. Unfortunately, dealing in the reviews of cases that have already had a conviction, that information is already out there. And a lot of times when you have a witness that is reluctant to talk or is hesitant to talk, there's usually some coercion from the police on the front end originally, where there were threats or promises made and maybe they weren't disclosed at the time. And, we just try to work through there to say, hey, we're not here to manipulate anything. What you have to say is important to us, but we want to hear it from you. I hope that answers your question. But yeah, I mean, there's a lot of contamination in the wrongful conviction cases, and we just want to steer clear of that.
So for example, I went kind of early on. I went to an interview with a prosecutor, and basically they said, "So everything you said at the trial was right, is that right? Is that how you would approach a witness interview?"
No, not at all. And I'll go back to Edwin Chandler. Okay, so Edwin Chandler, I found the White Sox guy hat. That guy wearing the White Sox hat, black male. They knew him at the store. He had nothing to do with the crime at all. He just happened to be the last person in front of the shooter in line. And then he walks out, didn't even know the shooting happened. Handy got a hold of him the next day. They show him a photo pack, and it wasn't the next day. It was about a week later. They show him a photo pack, and he says number 2 and 3 may look like the person. Well, 3 was Mr. Chandler, and they turned that into he identified Mr. Chandler. And at trial, in trial, the witness said, that's not him. And his son had got arrested by Louisville Metro Police for, I think, a drug case or something. And the prosecutor was able to show that he had a motive to lie and change his story now. And it was very contentious, and he was threatened to be put in jail. And so now I've got to go back and interview him. And on the Chandler case, and he didn't want to talk to me. And I finally met with him, and I said, look, I'm not here to manipulate anything. I don't want to, I just want to hear from you. And then I showed him a photo pack, and he did almost the same thing. And where he said, number 4 kind of looks like it. And that was the actual shooter. And I said, you're not making it, this is not a photo identification. And I'll testify to court to that. And that's where he got into all these threats and promises, indirect threats that he felt that were made by the criminal justice system on him during the Chandler case. I mean, he literally stood up in court and said, that's not the guy I saw in the store, pointing to Mr. Chandler, and they still convicted him. And he felt the system was against him. And so, no, I would never go in saying, hey, you said ABC. And because right off the bat, it's going to be a contentious. The way we did it with him is just went into him and said, we just want to hear your story from start to end. And then we may clarify, through, he may say, hey, I don't remember what I testified at trial. And we'll say, hey, we've got a copy of it, and we'll share it with you. We don't want it to manipulate your memory, but if it helps your memory, here's what you testified to, and let them read it themselves or read it to them. Hope that answers the question.
Did that answer your question, Nicholas? I'm looking at you to see if you're nodding along. It says, yeah, I think so. Okay. So, oh, Chris, you had a question about systems for organizing buckets of information. I don't know, Denny, that you have like kind of a systematic way of like kind of using software or something else to kind of put things together. You're talking more of a general, this is my approach.
Yeah. So, for example, the CIUs I've worked with some Kentucky Innocence Project, some other Innocence projects. When I get their information, I want to know where it came from. I want to know who I'm getting it from, because inevitably it's an onslaught of information, of documents. And I want to be able to show, here's the document that I read. It came out of this information, and this is who I received it from. Because many times you'll have, let's say, a defense attorney file, and then you'll have a prosecutor's file, and then you'll have a police file, and you find one document and you're like, okay, I don't think this was turned over in discovery. This could be Brady. Now, where does it exist? And if you don't have those buckets of information separated, it could get very confusing very quickly.
And are you using like a spreadsheet for that, or your own notes?
No, what I do is drop them in Google Drive, and whenever I get them, if I get a batch of information, I just drop it directly in from that person, and then go in and try not to manipulate the information, because I don't want to change the names of the files.
Got it.
Yeah.
So you've mentioned a couple times like things that when you read it, you kind of, that doesn't sit right or that doesn't sound good. So are there particular red flags that you're looking for as a former policeman when you're looking at a police file or a prosecutor's file that might set you on edge a bit, right? So, like for example, for Philadelphia, where I practice, it's a jurisdiction where they like to overtry their cases. If we had a case where there were lots of witnesses to the scene and nobody testified, that was a big red flag for us. What would you suggest are kind of your sense of investigative red flags that kind of makes you think there might be something here?
Well, and I think you have to attach it too with technology now. Everything is cell phone technology
Mm.
and, or computers. And I think if you're looking at something and there's a multi-defendant case or multiple suspects, what did they do to suspect one? And then you have your person claiming he's innocent that got convicted. Is there something different? Did they use a different protocol or a different practice? Meaning, we did search warrants on all the other defendants' cell phones, but we didn't do one on the guy now who's claiming he's innocent. That to me is important, especially if he's got a cell phone and the cell phone's missing. Um, it's things like that. Did we do a computer history search on everybody, but then we didn't do one on the defendant, or did we do it and we don't have a record of it? Because a lot of times the information is collected, and if it doesn't match their theory, it may not be saved. And I think that's more of a court issue, balance checks and balances, whether they're using court processes or not to get the information. We're finding that more and more common, to where if the information obtained to the police doesn't match the story that or the theory of their case, then it may not be put in the police file. And so now we have to go back to the source to try to track down, was this information ever collected? Was there ever reach out by the police department? And they're leaving a digital trail, and that's more and more common. That if that digital trail is happening for 3 defendants and not the 4th defendant, why? And that's the explanation that we go to, when we talk to the police or prosecutors to say, why did we treat this fellow different? Oh, and by the way, he's the fellow who's claiming he's innocent. So hopefully that answered the question.
But we've had other guests talking about investigations, and they have said that for with innocence cases, very often what they've seen, the mistake from law enforcement is that they go from an evidence-based investigation to a suspect-based investigation too quickly. That all that evidence that they're collecting in a general way, kind of now it starts getting targeted toward an individual. Is that what you've seen in your career, and how do you identify that, if so, when you're looking at a case for potential innocence?
Yes, no, I think that's a very fair statement. I think the police department works, and a lot of times you'll hear it's a gut feeling. You can have instincts, you can have gut feelings, but the facts still have to be the facts, and you cannot manipulate the flat facts or take 3 or 4 of the facts because they match my theory. I mean, you have to use it all, and that's where I think that's where the problems start to occur, is when we start thinking, okay, I think Edwin Chandler did it. I've got this guy that says someone else did it. I'll just leave him over here on the sideline because we've got enough information. This just weakens my case. And that's where the problems come in.
And you mentioned before, so actually, I'm a little curious in terms of, do you interview police or other law enforcement as part of your investigations usually? And how do those go? As yourself being a former law enforcement, are you met with skepticism, with kind of open arms? How do you approach those, and how did that go? And how would a typical lawyer who wants to do an investigation involving law enforcement, what would be the best approach for them if they wanted to?
I think I've had a lot of success with it. I think, I can speak the police language. Jim speaks the prosecutor language, but I think the police language, I know what the problems are in policing. I know the pressures they have, but when I go in and talk with them, it's very straightforward. Hey, I'm here to talk to you about this case. This person has a claim of innocence. I just want your explanation on, what happened. And more times than not, if they're willing to meet with me, I just let them talk. And then I'll usually have the 4 or 5, 10 things that are critical that are Brady violations that weren't turned over, or in some cases stuff was manipulated. And I'll just show them, hey, this is what was in court. This is what's in your file. These are two totally different. What's the explanation? And let them say whatever they're going to say. Because we have the facts. And then typically, whatever's manipulated, that's what they're testifying to in court. And it's under oath. But if it's in their original file, which that's why it's so critical to get this information on the front end and memorialize it of what we have, there is no explanation. And it becomes very clear. But to get over that hurdle of the police, we're very non-threatening because we don't have any authority, and we tell them that. But we also tell them, hey, we're going to turn this over to we're working with the prosecutor's office, and we're going to turn over our report. And if you say this is what happened, we're going to write it down and say this is what he said happened. If you say you don't remember, you don't remember. But whatever it is, we put it in there and send it over. We've had some, typically, if they don't want to talk to you, they just won't answer the phone, or they won't answer the door. And that's where I think the use of the grand jury is imperative. And I think it would be met with success after success, because when you give them a grand jury subpoena, the bottom of it, the way Jim and I always worked with it, if we had a witness that didn't cooperate, we'd give them a grand jury subpoena. And at the bottom of it, it would have Jim's cell phone number, my cell phone number. And, in lieu of you showing up to the grand jury, you can call these two guys. And almost without exception, we had our phone call that day and got what we needed. And it may be something very insignificant, or it may be something critical. But more times, I can't even think of a time where, well, I can, where we talked to someone and then went ahead and put them in the grand jury. And that was on the Handy case. We had a policeman that just was ignoring us and gave him a grand jury subpoena. He called us and talked to us, and we thought it would be best to go ahead and just lock him into his statement in the grand jury. And
you mentioned this before. And so, Jim, your partner, who is a former federal agent, we hope will join us next month in August. We'll continue this discussion and talk about grand juries and what they are and how to use them, particularly for prosecutors. So if you had questions about that, I would ask you to put a pin in that until August. And if we can't get to it next month, then November for certain. So there's a question from Destiny Des has another question in the chat about IT. Des, you want to go ahead and ask that?
So whenever you have digital evidence and it doesn't always make it into the file that they provide to the DA, but it's stored electronically, whether it be a recording, an audio video recording of an interview, or there's just no, the original item is not physical, it's digital, but it's on the computer, but was purposefully or accidentally left out. Do you guys have an IT, I don't know if it would be IT, but a tech person to investigate those types of things?
We don't personally, but what we do is the CIUs that we've worked with that this has become an issue, we get with not the police IT, but the government IT, and kind of walk us through what their process is on recovering data. And we typically use like waste management or another function of government, because they handle all the IT over all of government. And we'll say, if we wanted to find a receipt from the Parks Department 5 years ago, would you have it? All right, and then we transition to the police department and say, okay, how long do you keep information from the police department? And then if we wanted to find a recording, how would we do that? And it's just having a conversation with them, walking them through for them to understand what you're looking for, and then letting them go and behind the scenes. Typically, they can go in behind the scenes and hopefully find it or have an answer for you for whatever information you're looking for.
What do those conversations look like between different governments? I mean, you have smaller counties with a lesser population, and then you have bigger counties. So how do those conversations look?
Yeah, so the smaller counties, you're probably out of luck. I've got a case now that I'm working with a law school and their students, and it's in a rural part of a state, and they just don't have the infrastructure, and it's an older case, and the information just isn't there. And then other areas in urban areas, typically that infrastructure is there to where there's more of a footprint, a digital footprint that you can tap into. And I hope that helps. And you're welcome to reach out to me, and we can share more information, and hope, if maybe I'll learn something and be able to share some information with you on whatever the specifics are in the area you're in.
So Lorna McCluskey is on the call. She's the head of the Shelby County CIU in Memphis. And Lorna, you had said in the chat something about the think sessions that you've had with Denny and how helpful those are. And just as an investigative strategy, I'm wondering if you guys can kind of talk about what that means to kind of sit down either with the CIU or an innocence organization and kind of, I think you said this before, Denny, kind of plot out the investigation. What information do you need to be able to do that? Are you thinking about who we're going to interview, in what order we're going to interview, how are we going to approach that? What do those sessions look like for you guys? And Lorna, feel free to jump in on that.
Okay, first, hello. Hi, Denny. It's so great to see you.
How are you, Lorna?
I'm doing good.
Good.
I'll start off if you don't mind, Denny.
Yeah, please.
When you work with these guys, they will come in and we gave them kind of an outline of what we thought we had. And because we want the review to be excellent, we try not to push in any particular direction, just tell them what we have and what we think what we have means. Then we sit down with them after they have been provided all of the documents that we have. And as investigators, they tell us what they think we need. And we do our best to go and get it. What's been wonderful is they have had so much insight into how to go and get that. Maybe there's some back roads somewhere. We were pretty successful in getting a good bit of what they needed or felt that would help the investigation. We weren't able to ever get a critical piece of the puzzle that we wanted, but we've gotten enough that we're all very satisfied. And with Jim in the room at every step of the way, we were able to talk about the legal aspects of where we're going, how we could get it in front of the court, what laws would apply to this. It's really absolutely amazing working with such talented people.
I think the question for you then, Denny, is how can folks who don't have a Denny to be able to kind of sit with them, how can they make that happen on their own? Like, what is it about a think session like that? What would you encourage people to do in terms of coming up with their investigative plan and ways to think about it that they can do even on their own?
Yeah, so I'm glad Lorna's on here and shared that we're working with Memphis. I didn't want to. We sign confidentiality agreements and non-disclosure agreements when we get involved, and we've been working with Lorna and her group. Great group to work with. They're a new unit. I think they came through Cary Law School or through your all's program.
Oh no,
Marissa?
they're all on their own, but
Okay.
we did help a
Well, I
little bit
mean,
on the
I think we
transition.
got connected through you
Right.
to get involved with them, and we do it at no cost, and we review. The only thing we need is an actual claim of innocence. And when we have someone with an actual claim of innocence, then what happened in Lorna's case, we hooked up with Lorna and said, this is what we need, the buckets of information, and getting with the police department, the prosecutor's file, we start going through that, and then, we just sit down and kind of brainstorm the session through of, okay, here are key people that we need to interview, some more sensitive than others, some more critical than others. And then, everything has the proverbial pitch thrown in it, because this case is now kind of back into the court, and we're kind of in a hiatus. But I think we've done a pretty good review. There's still a little bit more to do, but I think we made a lot of progress with it, and it's been great to work with Lorna and her crew. And if someone doesn't have an investigator, feel free to reach out to us, and we'll see what we can do. Hopefully, we won't. And I see where Val is talking about Wayne County. The way I got involved in Wayne County is through an appellate attorney with the fellow. And when I learned that they had a conviction integrity unit there, I thought, if we're going to do the review and the work, why do we want to do it, double it up? Why don't I just partner with the conviction integrity unit and work directly with them? Val was gracious enough to hear us out. We partnered with them and worked a case with them that we were able to get the fellow relief last month.
It's amazing. And I want to get back to the kind of process in a second, but there's a question in the chat about funding for your organization, your nonprofit. How are you funded?
Yeah, so I am funded through, believe it or not, Delta Dental of Kentucky gave us the seed money. And we've gotten with some other Delta Dental corporations. It's the dental insurance folk. They are 501c4, and part of their mission is they have to give back to the community through nonprofits. And I was personal friends and known the CEO in Kentucky for decades, and he knew what I was doing and gave us the seed money to get started. I've got meetings next week and later this month with some other avenues of funding that we should be able to expand a little bit, and it costs the CIUs nothing.
Or Innocence
other than
works.
your time.
Right.
Yeah.
Right. But I want to get back to the kind of think session that you're talking about. So you had mentioned that you're looking for the sensitivity of information, to be able to look for identifying information. How are you looking at absence of information? Like, how do you approach that? Like something that should be there that's not. How do you approach that from an investigative perspective?
Well, obviously there's something to stick out that makes you think, why is this not here? And it's documenting those items that were there. In some cases you may have 4 defendants, and if 3 of the defendants' cell phones and were worked up, and we were able to show, okay, with defendant 1 they did this. Here's the time frame they did it in. This is the process they use, and it matches what they did with defendant 2. And then defendant 3 the same. And then defendant 4, there's nothing. That's a big piece of it. But then you start looking back, okay, if they had the evidence, the cell phone or whatever, what would it have looked like, and could it have been manipulated? And the answer is yes. And the way we were able to do that is to go back to defendant 3. They had the information, they did the search warrant. They don't turn in anything until they get the results back from their search. And then everything goes into the property room at the same time. So they're holding on to a key piece of evidence in a murder case. No telling where it is, but it doesn't hit the fellow's arrested on day 1. And then 5 days later, when the search warrant information comes back, that's when everything hits the property room, which that is a horrible practice, because in the case that we have with that, the person claiming he's innocent, there's no record of the cell phone even being at the police. And so we're able to show that if the information came back and it wasn't what they wanted it to be, they had the ability to hide it. And that I hope that.
Well, sometimes it's trying to prove the negative.
Yeah.
In a way.
Or getting the explanation of why didn't we do this? I mean, it's a key piece of evidence, and Mistakes happen, but if mistakes happen and you correct it right away.
Right.
And that's just,
If I could, I'd like to add something here
Please,
because
Lauren, go right ahead.
we did have something we wanted and something we couldn't find, but we felt it should be there. And Denny and Jim were great when we would sit down, particularly Denny, you on this one, because having been a police officer, he kind of knew where things might actually end up going. If they weren't where you thought they should be, he was able to tell us, okay, look, it might be with this division. It might, how about we look over there? How about we reach out to these people? And Jim was always there to talk to us about ways that maybe if somebody wasn't going to help us with it, we could invite them to talk to a grand jury. So it was those kind of things that they were helpful when we couldn't find things and we didn't know where to pick up the trail. They were there to help us do that.
Thank you. And Michaela has a great question, I think, for the end of our session. What is the best way to contact you for further questions?
let me give you my email, or I guess you could put it up there. How do I
I'll be
put it up
happy
there?
to. Is it okay to put it right in the chat?
Yeah. Oh, yeah. Yeah. Put my
Okay.
email and my cell phone up there if you don't mind.
Not a bit. Um, so I have the Gmail account. Is that the right one?
Yep. That's it.
Okay. Let me put that right here. Um, okay, and just kind of giving folks another minute or two to put more questions in the chat if necessary. There we go.
Yeah, and I think something too, Marissa, that could be helpful if you have a new unit and you have an investigator, we're happy to come work with them, or I don't want to say shadow them, but give them our suggestions, take a look at the case, and kind of let them work with us to show them what we do, and they may be able to pick up on things, and then again, we may be able to pick up things that they do. We're happy to work with them. Or your prosecutors.
Okay. And I think that's a great night. So thank you all for joining us, and thank you, Denny, especially for your time. We're so grateful for the help that you give us and everything that you do. So again, for next month, for August, we may be taking the month off for the summer. That's what we usually do to kind of give ourselves a bit of a break. But I can tell you that in September, we're having a forensic psychologist will be joining us to talk about child statements and how to kind of evaluate child statements for their reliability and accuracy, which I know is a very big issue with folks, particularly in looking at convictions involving a sexual assault of a child. And then in October, we're getting back to DNA. So we'll have more presentations on DNA from October and December. So, and in the meantime, of course, if other folks have a topic you'd like us to cover in this, please let me know. We're happy to do that. That's where we get most of these ideas. But please join me in thanking Denny for his time with us, and it's great to see everybody. Thanks for being with us.
Thank you.